My name is Erika Solimeo, and I'm a legal intern at Living Law, as well as a trainee lawyer in Italy. Building on our previous blog on the right to a safe and healthy environment, in this short video update, I would like to share with you some of the latest legal development and thinking surrounding the legal rights of and for nature, a topic which is gaining increasing traction and debate globally. Today, the impacts and price that nature, and eventually also people, have been paying as a consequence of overexploitations based on short-term and inequitable economic considerations is increasingly apparent, and a fact humanity can ill afford to ignore. We are already transgressing 4 critical planetary boundaries, which means we are approaching, and in some cases already crossing, tipping points in the Earth system. From ocean acidification to mass deforestation, plastic and chemical contamination of major seas, rivers and lakes across the world, they all illustrate the urgency of the remaining challenge ahead. Continuing failure to act will lead to possible non-linear feedbacks, with the result that impact may not be reversible. The consequences are not only for healthy and well-functioning ecosystems, but also humanity's very survival and international peace and security. Water scarcity being an obvious example where nature rights and human rights intersect. Yet, we also know that with purposive approaches and clear regulatory frameworks, we can set the direction needed to implement system-level changes. Done correctly, these can turn the tide. Recent examples of a little thought going a long way include the ban on single-use plastic straws, and clearly demonstrate that these changes can also be implemented in a sense that makes economic sense. It is clear that to actually implement the concept of sustainable development, both international and national environmental frameworks need to move far beyond the traditional approaches, which have thus far generally not halted the continuing decline in nature. In response, the real-world impacts, such as of climate change, have spurred renewed momentum at the international level in recent years, leading to increasingly high ambition and collaborative actions, such as the Paris Agreement and the SDGs. Yet, it's fundamental to the real-world attainment of those international commitments that national laws also keep pace with this transformative shift, to bend the curve to society within planetary boundaries. This is why we are today launching the new legal report Giving Nature a Voice, Granting Nature Legal Rights, which aim to promote debate in a key area where creative legal thinking has the potential to realize a better balance between people and natural world, and also support fulfilling pre-existing human rights. History has already demonstrated that progressive legal approach, even if at first appearing too radical or unworkable, have subsequently become basic founding pillars of our current legal system. Without bold and visionary thinking, for example, we may not have been able to celebrate the centenary of women's right to vote in the UK this year, or similarly have achieved universal rights of equality in race and gender in our legal system. When it is also understood that non-human entities, such as corporations, need the benefit of legal personhood and rights to protect them from arbitrary decision-making, increasingly the questions arises. Why should nature be different? Why should government face legal actions from fracking companies, even if proven erroneous, which claim their human rights have been violated without a corresponding balancing rights of and for nature? What is it that makes nature less worthy of rights-based protection? In Section 1 of our report, we provide a comparative legal analysis of key national jurisdictions that have already formally recognized right for nature in their legislations, constitutions and judicial cases, as well as the rationale for doing so. Whether driven by traditional deep-root connections with the natural world or the strong influence of indigenous populations, it is undeniable how those countries, by considering nature as a living entity capable of being represented before courts, have pushed the boundaries towards sustainable development one significant step further. Notwithstanding their own unique national characteristics, those examples also support the conclusion that a safe, clean and healthy environment represents a pillar in the enjoyment of fundamental human rights, as also recently acknowledged by the UN Special Rapporteur on Human Rights and the Environment, John Knox. It is important to stress, however, that our intention in publishing this legal report is not to conclude that nature recognitions are an end point in themselves, nor to suggest that operationalizing right for nature is completely straightforward. Indeed, we acknowledge the challenge that the jurisdiction we have studied have encountered in giving nature a real voice and the ongoing importance of regulatory framework and controls which actualize nature protection. And while mass-scale mineral exploitation, failures in enforcement and continuing environmental contamination still persist also in these same praised countries, we rather suggest that these are the consequence of piecemeal approaches, as opposed to being an intrinsic flaw in the concept of right of and for nature. Moreover, we do not believe that the challenges in implementing a right-based approach are insurmountable, particularly when taking a holistic vision in their development. Rather, we suggest that formal recognition of nature rights provide a clear normative shift and optic, also for the interpretation of existing regulatory frameworks, similarly to the way in which other pre-existing rights-based laws operate, and furthermore promote legitimacy, democratic accountability and participation in decision-making, as well as supporting the aim of leveling the playing field among corporate actors. Environmental rights also allow conscious decision-making around questions such as who should represent nature and within what institutional frameworks. Without it, decision may be arbitrary, unpredictable and lacking in legitimacy. And the evidence increasingly tells us that this optic shift is much needed. For example, notwithstanding the worldwide perception of UK environmental law as being highly sophisticated, in 2016 the State of Nature report found the UK's environment to be among the most depleted globally. The practical reality that the UK River Thames has been ranked recently as the most polluted river in the world is just one stark example of why increased debate on outcome-focused greener law and policy also here in the UK is urgently needed. Combined with the ongoing debate on the post-Brexit environmental protection frameworks and the prospect of a new Environmental Act at Westminster, this report is therefore timely. While the lessons from other national jurisdictions stress the importance of well-considered procedural requisites to concretely implement nature rights, the purpose of this report is not intended to provide, at this early stage, a blueprint to operationalize nature rights in the UK, nor to suggest inappropriate legal transplantation from other jurisdictions. Rather, we hope to encourage an evidence-based, bold and visionary debate on the possibilities of how rights for nature may stem the decline of our natural environment, promote a greater balance between people and nature to also support the attainment of fundamental human rights, assist governments to navigate complex decision-making in the Anthropocene where often competing and vested interests may be present, and debate which nature right could appropriately and realistically be conferred such protection. We further provide some examples of how nature rights have in practice been implemented in other jurisdictions, for example via nature ombudspersons, and also analogies from other legal fields where procedural mechanisms have been developed to successfully overcome the practical difficulties of where a claimant is unable to physically represent itself in administrative and court proceeding. It is important to stress that this challenge is not unique to nature rights. For example, the revolutionary figure of the curator ad litem was developed for children who lack legal capacity. In this latter case, these too require to overcome major cultural resistance to the opening up of court procedures to these parties. What was once viewed as too radical is now mainstream. The inescapable fact remains that the current state of our environment, severely degraded and overexploited, requires immediate and creative legal solutions. These changes are possible and have legal precedents to draw on other fields of law. As this report is published between the 4th and 6th of July 2018, leading legal experts from all around the world will convene here in Scotland for the 2018 AUCM colloquium hosted by the Strathclyde Centre for Environmental Law and Governance. Entitled Transformation of Environmental Law and Governance, Innovation, Risk and Resilience, it is notable that a specific session is also dedicated to this very topical issue, and specifically the possible role of nature rights in the field of climate litigation, sustainable development and preservation of indigenous peoples' rights. As the prominent Native American proverb says, we do not inherit the earth from our ancestors. We borrow it from our children. If we have to live up to those responsibilities, the issue of nature rights clearly merits further legal and policy debate to rise to the challenges of the Anthropocene. Thank you.